foreclosure fraud, securitization failure, and void judgments in the American mortgage system. 1. The fabrication of mortgage documents in judicial proceedings. During the 2008 financial crisis, large banks resorted to producing falsified mortgage documents in state foreclosure courts. Contrary to public assumption, this was not merely a cost-saving shortcut. In many cases, banks could not produce legal documentation proving ownership of the mortgages, as required in securitization trusts. Consequently, they fabricated promissory notes, assignments, and endorsements post-default to falsely establish standing. 2. The Simoniac lawsuit and the $1.4 trillion question. In a key TAM action filed under the False Claims Act, whistleblower Lynn Simoniac revealed systemic forgery within mortgage-backed securities. Her research demonstrated that trustees failed to properly transfer notes and mortgages into securitized trusts before closing deadlines, violating IRS and SEC regulations. The absence of legal ownership led to massive document fraud designed to retroactively validate these transactions. 3. Legal structure of securitization and failure of delivery. Each mortgage-backed security required that the promissory note and the mortgage be endorsed and transferred into the trust within a strict 90-day window. According to legal scholars and congressional testimony, if this delivery failed, the trusts held no enforceable interest in the loans. Consequently, the securities were legally unsecured, and foreclosures initiated by these entities lacked standing. 4. Fraudulent documents and the robo-signing crisis. To establish legal standing, banks and servicers employed robo-signers, individuals who signed thousands of mortgage assignments under false titles, often for defunct companies. Many documents featured forged signatures, mismatched dates, or template placeholders never replaced. These fabrications constituted a systematic breach of civil and criminal law, including perjury and fraud upon the court. 5. Legal consequences, void judgments and due process violations. Judgments obtained using fraudulent documents are void ab initio, legally null from inception. As defined in Reynolds v. Volunteer State Life and Clue v. U.S., a void judgment lacks legal force, cannot be cured or ratified, and may be challenged at any time. A court has a continuing duty to verify jurisdiction. Failure to do so, especially when founded on counterfeit evidence, invalidates its rulings. 6. Remedies and responsibilities of officers of the court. Attorneys who discover counterfeit promissory notes are legally obligated, under statutes such as New York's Penal Code, to report such findings within a defined period. Judges, too, act ultra vires when allowing fabricated evidence to establish standing. The doctrine is clear: no court may issue a valid judgment based on fraud. Such conduct invites both disciplinary action and civil liability. 7. Systemic risk and title clouding across the U.S. Private securitization trusts held 1/3 of all U.S. residential mortgages by the end of 2009. Because many of these loans lack valid chains of title, tens of millions of properties are subject to unresolved legal ownership. This not only impacts foreclosure legitimacy but also impairs the ability to transfer title, refinance, or lawfully convey property interests. 8. Public policy and the risk of repeating history. Despite evidence of systemic misconduct, federal policy proposals continue to favor the reintroduction of private mortgage securitization. The same banks implicated in document fraud may again control vast portfolios of mortgage-backed securities. This raises serious questions about institutional accountability and the wisdom of privatizing a foundational element of property law. 9. Constitutional implications and the breakdown of judicial integrity. Permitting banks to enforce void instruments violates constitutional due process. Courts that disregard forged documents abdicate their judicial function and compromise the rule of law. As articulated in Bruce v. Miller and Fritz v. Krah, a void judgment cannot invoke res judicata and may be challenged directly or collaterally at any time, regardless of closure. 10. Restorative justice and structural reform. Advocates propose full judicial reversal of void foreclosures, criminal prosecution of complicit actors, and restitution to dispossessed homeowners. Organizations like the Housing Justice Foundation call for legislative reforms to restore trust in America's land title system. True remedy requires acknowledging the legal status of past misconduct, and acting accordingly.